over the dates and times of those trainings at the end of the training today. And at the end, we'll hopefully have some time for questions. But again, if you have questions during the presentation, feel free to ask them in the Q&A. Okay, so just very briefly, what is the Pro Se Plus project, or PSPP? PSPP is essentially a group of about 7 not-for-profit organizations in New York City that got together to address and try to meet the needs of recently arrived immigrants in the United States and in New York City. And some of the things that we do as part of the Pro Se Plus project are community education, including presentations and providing educational materials to people who have recently arrived in the United States so that they have a better idea about the immigration process. We also provide similar trainings to community supporters, such as yourselves. So people who are helping community members and might be able to assist them or guide them through the immigration process. We also provide screenings so that we learn what their needs are, what they need help with. And we provide assistance for people who don't have a lawyer so that they are empowered to represent themselves in their immigration case. So very briefly, we're just going to do a review of the U.S. immigration system first. And this can be a little bit of a basic information, but I think it'll help us get situated as we move into the more complicated immigration system. So the federal government has 3 branches. The first branch is the legislative branch, or Congress, and their job is to write and pass U.S. immigration law. Another branch is the executive branch. This is the president and the different federal agencies that are under the executive branch, and their job is to implement U.S. immigration law. For this particular presentation, we're going to talk about 3 different departments under the executive branch: the Department of Homeland Security, the Department of Justice, and the Department of State. And we're going to talk about these specific ones because each of them play a specific and different role when it comes to implementing U.S. immigration law. And then the third branch is the judicial branch, or the federal courts. And they interpret U.S. immigration law. And I just want to make sure that for this specific slide, when I say courts, I am referring to federal courts. When we talk about immigration courts later on, I'm talking about immigration courts. It's a little bit confusing, but immigration courts are under the executive branch, and we're going to talk about that in a little bit. We're not really going to talk about federal courts in this presentation. We're mostly going to focus on the executive branch. So under the executive branch, like I said, we have the Department of Justice. And under the Department of Justice, there's 2 different offices that deal a lot with immigration cases. The first one is the Executive Office for Immigration Review, or EOIR. And the second one is the Board of Immigration Appeals, or the BIA. So EOIR is what we call the immigration courts, right? In New York City, we have 3 immigration courts, but EOIR, when I'm referring to EOIR hearings, I'm referring to immigration court hearings. Immigration judges are appointed by and they work for the administration because they're under the executive branch. And the immigration judges have the power to grant someone immigration status, and they can also have the power to deny immigration status and issue removal or deportation orders against someone in their immigration case. If the person has a case in the immigration court and the judge denies their immigration status and issues a removal order against them, that person also has the right to appeal that decision. And that is where that person goes to the Board of Immigration Appeals. So they would appeal that decision to the Board of Immigration Appeals. That is where removal orders can be appealed. The BIA also has the power to issue stays of removal. And this is for people who are in imminent risk of deportation. And if the person has an appeal in the BIA and the BIA denies that appeal, then the person has to seek remedies outside of the Department of Justice. And that is where we talk about the federal courts, the third branch of the federal government. They have to seek remedies outside of the DOJ and go to the federal courts. In New York City, that's the Second Circuit. So another department within the executive branch is the Department of Homeland Security, or DHS. So when I say DHS in this presentation, I'm referring to the Department of Homeland Security. And under the Department of Homeland Security, there's many different offices. For the purpose of this presentation, we're going to talk about three: Customs and Border Protection, or CBP, Immigration and Customs Enforcement, or ICE, and U.S. Citizenship and Immigration Services, or USCIS. So CBP, the CBP officers are at the borders, right, at the ports of entry into the United States. And they are in charge of border apprehensions, detentions, and removals or deportations from the United States. They are also in charge of verifying biographical information at the border. And they also take fingerprints and biometrics of people who are trying to come into the United States. And then lastly, they assess if the person has permission to enter and be present in the United States. So CBP is at the border. And then you have ICE. ICE is in charge of, or their role is arrests and detentions within the United States. So while CBP is at the border, ICE is inside of the United States, and they're in charge of arrests and detentions. I'm going to skip the second one for a second and go to the third dot. They're also in charge of supervisions. And what I mean by supervisions is ICE check-ins, which is one of the things that we're going to talk about a little bit later. And they're in charge of removals or deportations from the United States. Lastly, one of the things they're also in charge of is prosecuting removal proceedings. And what I mean by that is, like in a criminal case, in the criminal context, you have prosecutors from the district attorney's office. In the immigration context, in immigration court, you have ICE attorneys. So ICE attorneys are under the Department of Homeland Security, under ICE, and they prosecute people in removal proceedings in immigration court. The last agency that I want to talk about is USCIS. And USCIS is in charge of affirmative applications. So for example, there is someone who is not in immigration proceedings, does not have a case in immigration court, and they still want to file for asylum. They can still file for asylum, and they need to file for asylum affirmatively with USCIS. And other applications that USCIS also looks at are family and employment-based petitions, work authorizations, which we're gonna briefly talk about a little bit later, humanitarian parole, temporary protected status, DACA, and there are many more applications that people file with USCIS. Okay, so before we go into ICE check-ins and immigration court hearings, I think it would be best to take a look at some ICE and CBP documents that maybe you might have come across already, or you might come across in the future, just so that you know what these documents are, what information they have that is important, and the differences between these documents. Okay, so the first document that I want to talk about is the notice to appear, or the NTA. And the NTA is essentially, it's like a charging document in criminal court. So we have that notice to appear, or the NTA, in the immigration context. And then it's essentially a document that it means that the government is telling that person that they're starting an immigration case against them in immigration court. And some of the information that you'll find in the NTA that is useful is, well, it'll have the person's name, it'll have the person's address, and it's important to make sure that that address is still accurate. If that person has moved and the address is different, they must update the address with the immigration court, and we're going to talk about how to do that in a little bit. You will also find the person's file number, or a number, which is a 9-digit number that is related to their immigration court case. You also find the subject ID, and that will be useful for a couple of things. We're going to talk about that later on. In the middle of the NTA right here, you'll usually, there will be some stuff here, and these are the charges that the government is having against that person to justify why they think that that person should be deported from the United States. So it'll say something like, this person is not a citizen of the United States. This person is a citizen of Honduras, for example. They entered the United States on this date at this location, and they did not have authority or permission to enter the United States, something like that. And for these reasons, ICE believes that they are removable from they should be removed from the United States. So those are the charges, and that will be in the middle of the page. And then another thing to look for is at the bottom. Sometimes this information will be filled out, and it'll have information about the person's next court hearing. It'll have the location of the immigration court where the case is being heard, or where the case is at. That is also really important to know, because if you have, for example, a Texas address right here, or a Texas immigration court, but that person is now living in New York City, they must change or transfer their case from the Texas immigration court to New York City. And sometimes it'll also have the date and time of their immigration court date. That's not always accurate, so it's always good to double check, and we're going to talk about how to double check when someone has immigration court. So that is the notice to appear. Next, I just want to talk briefly about the order of release on recognizance, or the ROR. So the ROR is a document that the government gives to people who were detained and are being released from immigration custody or immigration detention. And this document has some requirements and conditions in exchange for that release. So it'll say something like, this person must check in with ICE, or this person must report to their immigration hearings, things like that. And then the second page of the ROR looks like this. And this is essentially a document where ICE keeps track of the ICE check-in appointments. So it's sort of like a record of when that person has attended their ICE check-in appointments. And it has also some information about that person, like their name, their A number, their address. And so if the person has an ICE check-in and they have to go in person, they have this document, they should always take this document to their ICE check-in, because that is how ICE will keep track of the appointments. The next document that I want to talk about is parole. So it'll come as either one of these documents, either as this card on your left, or this letter on your right. And parole is essentially a discretionary permission to enter the United States that ICE gives to people. It is discretionary, which means not everyone gets parole when they come to the United States. And it is temporary. It does not give someone immigration status. And usually what we've seen is that when someone is given parole at the border after they're released from immigration custody, it usually lasts about 2 months. So it's very, very temporary. And once a person is inside of the United States, they must seek more permanent immigration relief, for example, asylum. The next document is the notice to report, or the I-385. And this document is a newer document that ICE is giving to people when they're released from ICE, from immigration custody at the border. And it has just some basic information about that person. Again, you'll see the subject ID, and that will be useful when we talk about scheduling ICE check-ins in a few minutes. And then it has like information like the name, birthplace, the date that they were apprehended, etc. The last document that I want to talk about is the call-in letter. I think this is also a newer document that people are being given at the border. And it's essentially another document that tells you when and how you need to report to ICE for your ICE check-in appointment. So it has information about the location, the time and hour of the ICE check-in appointment. What I will say is that sometimes, or a lot of times, that information is wrong or it's not accurate. So it's always good to still schedule separately an ICE check-in appointment, and we'll go through how to do that. Okay, so then we can move on and talk about ICE check-ins. Okay, so before we dive into how to schedule an ICE check-in appointment, I think it would be better to review sort of the timeline of how an ICE check-in happens. So the first step is someone comes to the United States, they are detained by ICE or CBP, and when they are released, they are being released with some of these documents. The notice to appear, which we already talked about, the notice, or they can also be released with a notice and order of expedited removal, which essentially means that they were given a removal order, but they're being allowed inside of the United States. It's a little bit confusing. They can also be released under parole, which we talked about, and ATD, which means alternatives to detention, such as an ankle bracelet or something like that. Or they can also be released with a notice to report to ICE. They will also be given either an order of release on recognizance, which is the document that we talked about to track ICE check-in appointments, or a call-in letter, which we also discussed. Sometimes when people come in to the United States, they can give an address if they're thinking they're going to live in Texas or Arizona or any other state inside of the United States. But people move, right? They might now be in New York City. So it's really important for people to find the local ICE office, their local ICE office where they are now living, because that is where they need to report to ICE. And in order to find the local ICE office, they can go to this website right here, and it'll have the different offices based on their state and city. In New York City, the local ICE office will be at 26 Federal Plaza on the 9th floor. And after that, the next step is either to attend or schedule or reschedule their check-in appointments within 60 days. of their arrival in the United States. That is sort of what ICE expects people to do. Within 60 days of coming to the United States, they must schedule their ICE check-in appointments. So the next thing that I want to talk about is the steps for how to check in with ICE remotely. So I don't know if people have heard from the people that you're seeing or supporting, or maybe you've seen the news, but for people, when they go to their ICE check-ins at 26 Federal Plaza, what they find is really, really long lines and a long waiting period to attend their ICE check-ins. Sometimes they have to go at 6 in the morning and just wait for hours, and many times people are turned away and not being allowed to attend their ICE check-in appointments because there's just too many people waiting for them. So what ICE has done to sort of try to resolve this issue is that they've implemented a way for people to check in with ICE remotely. And the way that they're telling people to do this is to first, they need to schedule their ICE check-in appointment. And in order to schedule their ICE check-in appointment, they need to go to this website right here. They can also reschedule their ICE check-in appointment also through this website. So that's really useful. The next step after their ICE check-in has been scheduled and they have a date, they're saying that the person who is needs to go to their ICE check-ins can email ICE ERO at their appointment email address, which is listed right here, ERO NYC appointments, to check in via email. If that person, when they were released, they were issued a government cell phone or an electronic device like an ankle bracelet, they must email a different email address, and that is ERO NYC ATD. But if that person is gonna email either one of these, they are asking that, ICE is asking that they include the same information in the email, and that is their name, their A number or their file number, which you'll find in some of their immigration documents, their current address, their current telephone number, and if they have an ICE check-in appointment, to also include the date and time of that appointment. And that is sort of how they're telling people to check in remotely, to check in via the email address, to avoid them going to 26 Federal Plaza and being turned away. So when you go to this website right here to schedule the person's ICE check-in appointment, you'll come across this page. And this is the information that you'll be asked to give of the person who needs to schedule the ICE check-in in order to do that. So the first one is the subject ID, which is printed on the I-385 or the notice to report that we talked about, right? It's also, if you remember, it's in the notice to appear. So you can find it in those two documents. And they'll also be asked their place of birth. And then once you add that information, you'll be taken to the next page to schedule the ICE check-in appointment. And again, if you look at the notice to report, the subject ID will be right here in the middle, in the top, and their place of birth will also be there if you don't know it. And here we have a sample email that you can write on behalf of the person who needs to check in with ICE. If that person that you're supporting already has an email address and they check it often, they can also email it. You can help them write that email, and they can email using their own email address. But if they don't have an email address, or if they don't check it enough, then you can also write and send that email on their behalf. So the email will say something like, I am writing on behalf of this person. This is their A number or their file number. This person lives at this address this is their phone number. If they have an email address, this is their email address. They are writing to satisfy their reporting requirements and to schedule their next check-in appointment if required. And you can send that email to either ERO NYC appointments, or if the person has an electronic device or has been issued a government cell phone, to ERO NYC ATD. Okay, so we talked that in a lot of these documents will include the person's name and also their address. So it's always important to make sure that address is still accurate. If the person has moved, what they have to do is they have to update their address within 5 days for all relevant agencies. So agencies where they have some sort of case. So if they have to go to ICE check-in appointments or report to ICE, they must change their address with ICE. And in order to do that, they can call the toll-free hotline at this number right here. This is what ICE has told us that people can do to change their address with them. If the person has an immigration court case, if they are in immigration court, then they must also change their address with EOIR. And EOIR has a separate change of address form. It's called the EOIR 33. And if you type it in Google, it'll come up and you can print it and help that person that you're supporting fill it out. It asks for their previous address, their current address. And they must file the EOIR 33 with the court where the case is being heard. So in New York City, we have 3 different New York immigration courts, and the person needs to file their EOIR 33 with the court that has their case. So for example, if the case is at the immigration court at 26 Federal Plaza, but they go to a different immigration court in New York City, that immigration court is going to turn them away because they don't have their case. So that person needs to go to 26 Federal Plaza, if that is where their case is being heard, to file their EOIR 33. They can also mail it in to that immigration court. Then if the person has an application pending with USCIS, for example, if they have a work authorization application pending, they must also change their address with USCIS. And USCIS has its separate change of address form. It's called the AR11. And if you type it in Google, it'll also come up and take you to the USCIS website. You can file that AR11 online. You can also print the form and mail it in, but filing online is very, very easy. And one thing to remember is that if you changed your address, or if you help someone change their address with one of these agencies, it doesn't mean that their address is updated with the other ones. These agencies don't talk to each other. So if a person has a nice check-in and they're in immigration court proceedings in immigration court, they must change their address with both ICE and EOIR. If the person is in immigration court and they have a work permit application pending with USCIS, they must change their address with both EOIR and USCIS separately. Okay, so the next thing, if we're okay to keep moving forward, that I want to talk about is EOIR immigration court hearings. So we already looked at this slide, but it's good to just review it again. So the Department of Justice that we talked about is under the executive branch, and under the Department of Justice, you have EOIR, or the immigration courts, and you also have the Board of Immigration Appeals, or the BIA. So when like I said, when I talk about EOIR hearings, I'm just referring to immigration court hearings. And in order to check if someone has a hearing in immigration court and making sure that they know the date and time of their hearing, there are two ways to check whether that person has a hearing. The first one is by going to the EOIR website, which is listed right here. And if you go to the EOIR website, you'll be asked to give that person's A number, which again, you can find in some of their immigration documents. And once you provide the A number, you'll be taken to another page that has information about the person's hearing. So it'll have the date and time of their next hearing, what type of hearing it is, and we're going to talk about the two types of hearings in a little bit. So it'll tell you what type of hearing, the date and time of the hearing. It'll tell you the immigration judge that has been assigned that person's case. And it'll also give you the address where the case is being heard. So which immigration court the case is being heard. You can also find the same information by calling into the EOIR hotline. And again, you'll be asked to provide the person's A number, and you'll be given different options. I think either option 1 or option 2 will take you to find out when the next hearing date will be. And sometimes when you check for the next hearing date, for example, if you check it online and you type in the A number, sometimes you'll be taken to the next page and it'll say something like, no hearing has been scheduled, which means that that person does not yet have a hearing. But it doesn't mean that it'll never be scheduled, right? So it's really important if you see that, that you tell that person that they need to continue to check in, to check the website or call into the hotline to make sure that they know when their next hearing will be. I suggest to people that they check at least once a week, just to make sure that they're not going to miss any of their hearings. And the reason why it's important to check is because it's really important for people to go to their immigration court hearings, because if they do not go or they miss their immigration court hearings, what will happen is the judge will issue a deportation order or removal order against that person for not being present at their hearing. So it's really important that people continue to check and attend their immigration court hearings. So there are two types of immigration court hearings. And the two types are the master calendar hearing and the individual hearing. So the master calendar hearing is sort of like a preliminary hearing. It's very quick. It usually lasts about 5 minutes. And this is where the charges that we talked about that are in the NTA, the notice to appear, they'll be discussed. The charges will be discussed. And the judge will also ask the person what type of relief they are seeking. So if the person, for example, is seeking asylum, they can tell the judge that the type of relief that they're seeking is asylum. If the person goes to their master calendar hearing and they don't have a lawyer, but they are looking for one and they want to get a lawyer to represent them in their case, they can tell the judge that, right? Once they're in front of the judge at the master calendar hearing, they can tell the judge to please give them more time to allow them to find legal representation. And usually judges, at least for the first and second master calendar hearings, they will agree to that. They will say, okay, I'll give you another master calendar hearing date to give you more time to find a lawyer. So if someone doesn't have representation, but is looking for one and wants to get one, they can get more time by asking the judge to give them another date for their master calendar hearing. And usually you're gonna have at least one master calendar hearing, sometimes more than one master calendar hearing, especially if you ask for more time. The next type of immigration hearing is the individual hearing, and this is the trial, right? Just like in the criminal context, you have the trial. the individual hearing in the immigration context, that's the trial. And this is where the evidence in support of that person's case and application for relief is presented. And usually, actually, you have to, or the person who has the case has to provide the evidence in support of their case, either 15 days or 30 days before the date of the individual hearing. It really depends by judge. Some judges prefer 30 days before the hearing. Some judges are okay with 15 days before the individual hearing. So if the person is not sure when they need to present their evidence, they can always contact the immigration court where the case is being heard and ask what the judge's preference is. But at the individual hearing, what will happen is the judge will go over the evidence that was submitted. And then the person will also testify about their case. If they have any witnesses, those witnesses will also testify. And at the end of the hearing, the judge will issue an order. They will grant the relief that that person is seeking, or they will deny that relief and they will order removal. So they will issue a removal order against that person. And again, if that happens, that person has the right and the opportunity to appeal that decision to the Board of Immigration Appeals. Okay, so there are 2 ways for people to attend their immigration court hearings. Before the pandemic, it was always in person. You had to go in person to either of the 3 immigration courts in New York City. But now, because of the pandemic, people are able to access and go to their immigration hearings either in person or virtually. So in person, like I said, there's 3 immigration courts in New York City. They're at 26 Federal Plaza, 290 Broadway, and 201 Varick Street. So they can go in person to wherever the case is being heard, or they can also attend their hearing via WebEx. And WebEx is sort of like Zoom, and people can download WebEx. It's an application. They can download it to their computer or to their phone. So it's a good idea to do that before the date of the hearing. And they can go to this website right here. And when they go to this website, they can go to the New York City courts and find the judge that is going to be hearing the case. And once they find the judge, they'll also find the WebEx link that is specific to that immigration judge, because each judge has a separate WebEx link to access their specific courtroom. So that is how they would be able to access or attend their hearing via WebEx. If someone cannot go in person, if someone cannot attend their hearing via WebEx, there's also an option to call into the hearing. And if you go to this same website, you'll find a number at the top of the page, the number to call on your phone. And then if you go down again to your specific or that person's specific judge, there will be an access code that person needs to type in after they dial the phone number to access that judge's specific courtroom. What I do recommend is that I think most judges are okay with people attending their master calendar hearing, their preliminary hearing by phone. But if someone has an individual hearing, it is always best to either go in person or attend via WebEx, because the judge needs to see that person either in person or via video. It is not recommended that the person call in or use their phone to call into their individual hearing. And this is what the notice of hearing looks like. This is sort of why it's really important to update, to make sure that that person has updated their address with the immigration court, because they will receive these types of notices in the mail. If the immigration court is not going to call them, send them an email with their immigration hearing date. So it's really important that they have the right address, and they'll receive something like this. The notice of hearing, sometimes it'll say notice of just hearing. This one says notice of internet-based hearing, so you already know that it'll be via WebEx. Then it'll have information about what type of hearing it is. This one is an individual hearing. Sometimes it'll say a master hearing, and that's a master calendar hearing. Then it'll have the date and time and the location of the court where the case is being heard. At the bottom of the notice of hearing, sometimes you'll see a QR code like this one right here. And if the person goes to the QR code, it'll take them to a page that has a notice of hearing translated to different languages. So that might be useful for them to see, just so that they understand. If they don't speak English, they understand what the notice of hearing is telling them to do. Okay, so the most important takeaway, I don't know if I made it super clear what the most important takeaway is, but I hope to make it clear now. The most important takeaway, something that I really want everyone to understand and relay to people that you're supporting, is that going to your ICE check-in appointment does not mean that you're going to your EOIR or immigration court hearing, right? There are two separate things. If you remember, ICE is under the Department of Homeland Security. EOIR is under the Department of Justice. They're two separate agencies. They don't communicate with each other. So if ICE, if a person has an appointment with ICE for their check-in, and they also have their immigration court hearing, they must attend both. They can't attend just one. The reason for this is because, like I mentioned already, if someone misses their immigration court hearing, they will be ordered removed. It's called removed in absentia. It means they're being removed for not being present at their immigration court hearing. Sometimes ICE, what they'll do is that they'll schedule their ICE check-in on the same date as their immigration court hearing, just to make it easier. But it's important to know that if the person has that ICE check-in appointment and EOIR hearing scheduled on the same date, they must attend both. So I hope it's clear that there are two separate things. Okay, so I want to talk very briefly about asylum policies and procedures. Like I said, we're not going to talk too much about asylum, but just so that you have a basic idea, and then we'll have future trainings on asylum that will go more in depth into the process and the requirements. So there are two ways to file for asylum in the United States. You can file for asylum defensively, or someone can also file for asylum affirmatively. Someone has to file for asylum defensively if they are in immigration court proceedings, right? If they have been issued a notice to appear, an NTA, and the NTA has been filed with immigration court, meaning that they have an immigration court case, they must file for asylum defensively with the immigration court where the case is being heard. If the person never received a notice to appear, if the person is not in immigration court proceedings, they can still file for asylum, and they file affirmatively with USCIS. With both of these applications, it's the same form, and the requirements are the same. And some of the requirements, two that are really important, are that the person must file for asylum within 1 year of arriving in the United States. That is what we call the 1-year filing deadline. And if they miss the 1-year filing deadline, they can still apply for asylum, because there are exceptions. There are exceptions to the 1-year filing deadline, but it just makes it a little bit more complicated. So it's always important that people file for asylum within 1 year of arriving in the United States. And a requirement for asylum is that they must fear persecution in their home country. And just a reminder that asylum applications must be filed in the appropriate location. So if it's defensive, as a defense to deportation or removal, they must be filed with the immigration court where the case is being heard, where the case is at. Or if they are not in immigration court, they must file affirmatively with USCIS. And then just very briefly, again, about employment authorization. Some people might be eligible for apply for employment authorization for a work permit. So if someone files for asylum, they can apply for employment authorization after 150 days have passed since they submitted their asylum application. So what I will say here, if you file someone files their application defensively with the immigration court, it's always good if they're filing it in person at the filing window, that they take the application, a copy of the application that they want to submit to the immigration court, and they also take a copy for themselves, because what the person at the filing window will do is that they will put a stamp on that person's copy of their asylum application with a date that it was filed. So that'll help someone figure out how many days have passed since they submitted their asylum application. And after 150 days, they can apply for employment authorization. When they get it, the employment authorization is valid for 2 years and they can renew it. Then people can also apply for employment authorization through parole. Like I said, parole is very temporary. Right now it's being issued for 2 months, sometimes longer, but we're seeing 2 months for the most part. And the employment authorization is valid only as long as the parole is valid. So if parole is only valid for 2 months and that person submits their employment authorization application, it's very unlikely that they'll get the approval and the work permit before the parole has expired. So sometimes it might not even be worth it to apply for employment authorization under parole. It just depends on when the parole expires. And then another way to apply for employment authorization is if someone has an order of supervision. An order of supervision is usually given to people who are detained and then released by ICE, and ICE wants them to check in with ICE with them more regularly. Not everyone gets an order of supervision, but if you see someone that does have an ICE order of supervision, they may be eligible to apply for employment authorization. For all of these ways, it's the same application form. It's Form I-765, and you can find it on the USCIS website. You can Google it and it'll come up. And they must be filed with USCIS. There is a $410 filing fee for the employment authorization. What I will say is for people who are applying based on their asylum application, the first time that they apply for employment authorization is free. There is no fee. But after the 2 years, if they want to renew it, they do have to pay that $410 unless they're eligible to apply for a fee waiver to waive the application fee. And then I know we only have 8 minutes left for the presentation today, but I just wanted to go through the upcoming trainings. If you're interested in learning more about how to support someone in completing their asylum application, there's a training on April 17th at Mixteca, which is in Brooklyn. There will also be a way to access the training via Zoom. If you want to learn more about how to help someone change their address or change their venue, and change of venue, what I mean by that is if the case is in immigration court in another state, like Texas, but that person is now in New York City, they must ask the Texas immigration court to transfer the case to the New York City immigration court. So change of venue is how you do that, and that training will talk a little bit about that, and how that process works. And then lastly, on June 20th, also via Zoom, we'll have a training to go more in depth about applying for employment authorization. And that's all that I have for now, unless people have questions, and yeah, or maybe need me to explain something a little more. And also feel free to ask the questions in the Q&A. If not, I think very quickly, because we're running out of time, I'll take a couple of minutes just to talk about some frequently asked questions. So I see some questions in the Q&A. I think my colleagues are going to answer some of them, but what happens if you file the I-589 after the parole period? You can file the 589, the asylum application, after the parole period expires. That is not a problem. The only thing to keep in mind is that people must file for asylum within 1 year of arriving in the United States. And let's just go through a couple of these questions. Okay, can someone apply for asylum if they don't have an A number? So if someone doesn't have an A number, it usually means that they're not in immigration court proceedings, and they must file for asylum affirmatively with USCIS. So they can still file for asylum if they fear persecution or harm in their home country. They can still file for asylum. They will just need to do so affirmatively with USCIS. Does someone have to wait for their court date to file for asylum if they have received a notice to appear? So no, someone does not have to wait for their court date to file for asylum. Again, they have to be conscious of the 1 year filing deadline. That's the most important deadline that they have. So if they're coming close to the 1 year filing deadline, or they just want to apply for asylum before their court date, as long as they have a case in the immigration court, they can submit their asylum application. And they just need to go to the immigration court where the case is being heard and go to the filing window. At 26 Federal Plaza, it's on the 12th floor and the 14th floor. But you can, double check depending on the court where you need to go file. But it's not necessary for someone to wait for their court date to file their asylum application. This question might be the last question that I answer, just so that we can end at 12. How do we make sure that we're not engaging in the unauthorized practice of law? This is a good question, right? And a question that you might be asking yourselves. And I think anything that we talked about today during this presentation, and any of the presentations that we're giving about the immigration process, asylum process, employment authorization, this is information that is not, you're not practicing law by giving this information to people, right? You're not giving people legal advice, or counseling them in their immigration case. And that is why we're giving you this information, so that if someone comes to you and they have questions about their ICE check-in, or they have questions about how to find out they have an immigration court hearing, that you're able to provide them with the information that they need, so that they feel empowered to advocate for themselves in their case and represent themselves also in their case. As long as you tell the person that you're helping that you're not a lawyer, that you're not providing them with legal advice, and you're not representing them in their immigration case, the information that you're giving them is not considered legal advice, and you're not engaging in an authorized practice of law. Okay, I think unless people have questions, another thing that I will say, if people are interested in how to fill out their asylum applications, I know we have a training on how to support someone in filing asylum applications. Also on our website, if you go to unlocal.org, we have a presentation uploaded in Spanish for community members on how to fill out their asylum applications. And we'll also have future trainings on that as well. So just make sure to keep in touch, and we'll send emails about those presentations as well. Okay, I think if there's no more questions, if you have any questions that we haven't answered, there's a survey that we're sending, so please feel free to ask it there, or you can also send us an email and we'll try to answer your questions. But with that, I want to thank everyone for joining us this morning. I hope this presentation was useful. We'll share the slides with you all. I think we have already, but we can send them again. And thank you all so much for joining.